March 29 at 5 p.m. Central Time. Along with me is my business partner, Reddy Neumann. We're going to discuss today about the USCIS has recently released a public to the public that they're going to cut the processing time of everything what they have, and we'll have to see whether we can trust the USCIS. And they discuss, the new regulations are coming with regards to the premium processing of EB-1C and EB-2 NIWs, but they did not include the H-4 EAD in the premium processing, at least for now. H1b Lottery system, we have already noticed that we have received the selection. Is it over? Are we going to get any more? Getting selected right now to file until June 30th of 2022. We're going to also discuss about, is USCIS on its way of wasting 100,000 green cards? And I would have to repeat to say again. The reason is that they wasted almost 70,000 last year, and they are on the way to waste 100,000 green cards. We're going to see how the things are going on that. Emily, what do you say about this processing timing though? They said that the processing time they're going to cut down EADs and advanced paroles, I-539s to 3 months. And they said H1b non-premium is going to be 2 months. And they're saying that the I-140 and 400s, 485, that's one we're all looking for, that they're going to cut down for 6 months though. And this, they're going to achieve it by September of 2023. What's your opinion on it? Can we trust them? Because by that time, September of 2023, whatever excess green cards that we have are not going to be there. And the wording that they used is that cycling time goals. What is cycling time goals?
Yeah, they sure talk a good game, but I think this is more smoke and mirrors than anything else. These are processing times that we had back in the good old days before Trump. I mean, a lot of the stuff, we were getting approvals of I-140s and 485s in 6 months. We were getting I-129 approvals in 2 months. We were getting EADs in 3 months. We're just going back to the old days, but they made it very clear. They're not saying processing times. They're calling it cycle time.
What is cycle time?
It's an internal metric. And the best way I can understand it, it is their goal for the number of months of cases that they have waiting each month.
Wait, can you read exactly what the cycling time is?
Let's see.
Well,
I don't have it on this page, but basically it is, how many months worth of pending cases for a particular form are awaiting decision. So if they're saying a 2-month cycle time, that means they have 2 months worth of cases sitting there collecting dust. That doesn't mean they're going to be approving them in 2 months.
I don't understand these people. But anyway, coming to the point, most of our guys, Emily, the 485 applications by the time 2023 though, even if they want to adjudicate, the priority dates are going to backlog after September of 2023. So even if they achieve this goal though, our guys are going to be out though. It looks like, it doesn't look like they're going to benefit. Definitely we want everybody to take action. Please contact the congressman, senator, and all different offices to have the 485 adjudicated faster. And tell the USCIS, stop talking, stop issuing the notifications, stop going to Twitter, just go to your office and do your damn work and adjudicate the application. Now, if it's a genuine application, it deserves to be approved. What if it's a wrong application? You're issuing them EADs, you're issuing all the benefits for them to stay in the United States. Deny those applications, but take a decision on the application that have been filed. Why are they approving? If they're going to achieve the 6 months goal of 485 though, they don't need to worry about the EAD in advance parole though. They may as well skip those things and just adjudicate the 485 application. That'll be much benefit. They have issued saying that, we are going to adjudicate all these cases faster, and come this quarter, first quarter of 2022, which ended in December 31st of 2021, which is a fiscal quarter though, they only approved 33,000 cases, Emily. If they go in that pace though, they're going to waste 140,000 green cards, 150,000 green cards. They cannot even adjudicate the 140,000 that's allocated for the excess green cards. So definitely we need action from you guys. We need you to write the letters. They are responding to your letters. The only problem is they are responding to us they are responding to your letters, they are responding to your things in the press releases, they are responding to in the Twitter, they're responding when they go speak with the press, they're responding when they go speak with the Congress though. What they are not responding to us right now is just adjudicate the damn 485 application, adjudicate the damn EAD applications though. So that's what they are not responding, but they're responding in all other things though. Stop talking and adjudicate the applications, USCIS. Can you not listen to us? Can you not understand? And one of the other issues that I have is that, as you rightfully pointed out, Emily, that after the Trump administration came in, that the whole delay started though. But then after the Trump administration came in, they put a lot of hurdles though. For example, I mean, they started the biometrics though, for especially H4s and certain other things. They have taken it off for H4s and H4s and L2s though. But there's still a lot of other things that they need to simplify the process. The 485 form is so long to have it. The receipt notices are taking 3 months though. We have filed the 485Js for the upgrading of the applications in the California address that they have given. We still did not receive the applications that we filed in February 1st. Receipt notices. Forget about the approvals that these people are speaking. They need to get all these things faster though, rather than stop interviewing the people for 485. They used to interview only 1 in 100 case, especially, or 1 in 200 case, especially if there's any major criminal things. So now they're interviewing almost 20% to 30% of the people are getting the 485 interviews. Stop interviewing those people. Those steps need to be taken to get to the 6-month stage. These people, if they want to get to the 6-month stage by September of 2023, they should start working right now, not go all the way to August and scramble there at that point of time. They need to simplify the process. First of all, if a company has an EB-3 approval, if the same company has an EB-2 approval, they have filed the 485 application, why these goddamn people need a 485J supplement to approve it? They already have it. They went and they issued a notification saying that, oh, now we have come up with a new method for you to upgrade the application into EB-3 to EB-3, EB-2, and we are going to efficiently adjudicate your application. We send all these applications. Guess what? They don't even issue the receipt notices. Now they come back and tell us that by refiling the application, you may not get the advantage. They tweeted it out. What do you say about it?
Yeah, that is completely false. I mean, you just have to look at the data. With the refiled applications, they're going to a different service center when the I-140 is approved. It's a standalone filing. We are getting the results there. We're not getting the results with the interfiling. And they're not saying don't refile. They're just saying you don't have to refile, which we already knew that. We knew all along we have the option of interfile versus refile. But we're seeing a major benefit of the refiling is you're getting out of the Texas Service Center, getting out of the Nebraska Service Center, and getting much faster processing elsewhere. So yeah, I don't put much stock in their tweets. They definitely, with all of these announcements, they use very specific language so that they can weasel out of it later. I don't see it. I don't see much coming out of this.
Everybody who is here should ask the USCIS to adjudicate the applications. We have put the sample letters. If you have not written, please write those letters. They are becoming very good. They are getting to the attention. But we need to also understand that these people are going to Congress and showing this sheet, what they released it today, saying that they are going to cut the timings of those things. How? How? Explain it to me. Listen to us. We will suggest you some of the things though, where you can simplify the process. Adjudicate the 485 application. You can reduce the time on EAD and advanced parole. Now, they're adjudicating the EAD faster. That's coming very faster for at least some folks. But the advanced parole is not approved.
Yeah, and now they're going to waste their time on a regulation to make the automatic extension of EAD longer because they can't keep up with even a 6-month.
What did you say about that, Emily?
Yeah, so
can you explain that, please?
As part of these efforts to help improve the process, they announced that they have started the process for a temporary regulation that will expand the automatic EAD extension for certain applicants. So I am assuming that this mainly is for green card EAD renewals, a C9 AOS EAD. We've told you that when you file that renewal, you get the automatic extension for 180 days. Well, guess what? Processing time is more than 180 days. It's over a year, but you can only file 6 months in advance. So you have a 12-month window that they can't even do that. So now to fix that, rather than fixing the processing times, we're going to issue a regulation to extend the auto extension. That's their solution.
So for example, if my EAD is expiring in May of 1st of 2022, I file the EAD extension under the adjustment of status. Now I can work up to 6 months after May of 2022, which will be June, July, August, September, October. Until November of 2022, I can work. Instead of that 6 months, they're going to make it 1 year, most probably. That will be May of 2023 when my extension is pending. But that doesn't solve the problem. Why can't these people just adjudicate the 485 so that they can deny the EAD application? Because if I'm eligible, I'll get the green card. If I'm not eligible, I should not be getting the EAD at all. So that definitely doesn't, the way they are announcing it, and especially I saw the news in CNBC, this channels and that channel saying that we are going to reduce the processing time, but I don't see any efforts made by the USCIS director. What I have seen though in Bush time, Emily, that was in 2001, Bush issued a notification. As soon as he came to power, he issued this. He issued this notification saying that I want to cut the processing time. You know what the USCIS did? They didn't do anything in the 6 months. Then what he did? All the district directors are fired 6 months from now. He didn't fire them immediately. Guess what happened in those 6 months? In that 6 months span though, the processing came down lesser than what they have announced it today. These people are telling that by September of 2023, they are going to reduce the timing. We don't even know if this government is going to be there coming forward in 2024. We don't even know. And these people are announcing right now that saying that by September of 2023, by that time, a lot of people will go out of status. A lot of people will have a lot of trouble. The priority dates are going to move back. The number 6's green cards are not going to be there. I think so they need to take drastic action. And they need to also, I believe that, I mean, this is something, since the rest of the world people can get the green card afterwards too. But the Indian nationals will lose the numbers if they don't give the green card. I think so they should prioritize the Indian nationals and Chinese nationals this year so that we don't waste the green cards. So that's what I believe they should do. But please keep writing the letters by modifying them. Anything else, Emily?
All right, I think
premium processing. We were expecting premium processing on the H4 EAD. That's a very disappointing. What's about this premium processing update though?
Yeah, so this goes back 2 years to when USCIS was running out of money and getting ready to furlough 13,000 employees because they didn't have the money to continue operating, let alone adjudicate applications. So Congress comes in, saves the day with the Emergency Stopgap Stabilization Act just for USCIS to provide special funding for them to get back on their feet. Part of the way of doing that was through generating more fees through additional premium processing. Well, who needs premium processing right now? H-4s that are taking over a year to process, L2s that are taking over a year to process, H-4 and L2 EADs that are taking over a year to process. Now, we don't need L2 EADs anymore, thanks to litigation, but that was the main thing we were expecting, was USCIS to implement premium processing for additional categories of I-140s, as well as I-539s, which is the H-4 and the L2, as well as EADs. Finally, we have the final regulation that's going to be published tomorrow to take effect in 60 days. And what do? They make premium processing available for I-140 EB-1C, which is good, EB-2 NIW, which is good, and I-539s for F1s, J1s, and M1s. That's it.
What about H4 EAD?
No, not even
on
the
H4?
radar. Not even on the radar. Now, H4s, you are going to be able to do premium processing by 2025 fiscal year. 2025. It's going to take them that long to implement premium processing for I-539s, for H-4s, L-2s, all the other categories. They're only implementing it for F, J, and M right now. Now they also are implementing premium processing for I-765s. Great. Who qualifies? Only F1 OPT. That's it for this fiscal year.
What happened to the H-4 EADs?
The H-4 EADs aren't even mentioned in the regulation.
What about 485 EADs?
No, they're not mentioned in the regulation. The only thing they said is they're prioritizing F1 OPTs in this fiscal year. In fiscal year 2025, they have another category of I-765 that they may try to implement, but they don't say who's in it. And then they have an even other category of people who are eligible for I-765, which they have no intentions of implementing premium processing at all. But they don't tell us who's in that
What about the H-4 EAD or adjustment of status EAD?
They
We don't know whether they're going to be there in 2025 or not.
Nope.
Oh, golly. This lazy administration, though. They do have good intention, at least on the word-wise, though, but I believe that the USCIS director need to be changed, fired because of the inefficiencies that she has. Even though her intentions might be good, she needs to understand that she is not fit for the job. I cannot understand the way that they're trying to do it. I mean, that should have been done when she came into power immediately, when the administration came in. Now we are down 2 years down the line. What are we doing? Nowhere we are in there. So let's discuss about H1b Lottery, Emily. I know that H1b Lottery, we started getting the things Saturday?
Friday, 5 o'clock.
Friday, 5 o'clock, we started getting it, and then probably on Monday, we're pretty much done with it, is it right? I mean, we're not getting any more selections right now.
Right, yeah, we did get them Friday and Saturday. We got notification emails this morning at 8 a.m., but all of those notifications were relating to selection notices dated before today. So it doesn't look like any new ones were uploaded today. And then USCIS finally announced today that they completed the process and they finished notifying all of the registration petitioners, the companies and the attorneys. So everybody who's been selected, that information is already in the My USCIS portal. They're not adding any more. So we are done with it. Obviously, companies, especially those that have a lot of registrations, they may take longer to notify the employees, but in terms of actual selection notices, they're done with those as of today.
And do you know how many applications were being received by USCIS?
No, we don't. They did not announce that, which they did last year, so that's interesting as well. Last year they announced how many there were total, as well as how many were masters, and how many they selected. This year, no information.
Okay. Emily, if at the pace at which these people are going, how many green cards will be wasted this year? Employment based.
Well, assuming they keep going with what, 33,000 a quarter, that's 120 some odd thousand.
Yeah, 130,000.
And we have 280,000,
130,000.
so 150,000 could be wasted.
So what we're telling 100,000 waste probably may not be true.
Yeah, maybe worse.
Unless they pick up the pace in this quarter, in the coming quarter, they are going to waste 150,000 if they go at the same pace of what they went in the first quarter, though. So if you guys are waiting for the green card, if you are in the 485 application, or even if you are just H1B person, F1 person, you're waiting, you need to write these letters, because if Indian nationals are not going to get the green card this year, though, all those extra green cards will be wasted. Most of them, they cannot get it at later years. The reason is that the numbers are going to go back. Since we have this extra 140, 150,000 green cards, they all will go to the countries that have been waiting for a long period of time. If they are going to be wasted going forward though, Indian nationals are only allocated up to 7% of the entire 140,000 green card, which will be only 10,000. That includes the family members. That's only 4,500 4,500 people. The entire, just 4,500 people will get the green card though. So that's going to take, like, we may be wasting 20 years of our green cards this year if they don't. So if your priority doesn't move, you don't get the green card, buy this excess green card. So you may have to wait for a next generation, maybe up to 20, 30, 40 years, even 50 years for you to get the green card. So please write the letters that we are putting in there. We're going to go to questions. We're going to go to questions and answers, guys. Holy Margarita does it clears the DUI issues as well during the GC interview? No, Madhu, it does not clear it. What Holy Margarita does is that, what he's speaking about is by going to Mexico and coming back, is that if there is any status violation, especially for example, if on a student visa you violated, you may have worked in some place you're not allowed to, or you may have an employment gap which is long period of time, those things will be. But if it's a DUI, it will not be clear.
Morelli Krishna wants to know if the EB-1C will be eligible for premium processing and when will that take effect. So yes, with this new regulation that's going to be published tomorrow, the regulation takes effect 60 days from tomorrow, which does expand premium processing to I-140s in the EB-1C category, but it says that USCIS will update its website when new categories are actually becoming available. So I would not expect them to immediately accept those applications 60 days from tomorrow. We have to wait and see when USCIS updates the website for when they will start accepting these new categories.
Joy is asking this question, will they have a premium processing for 485? Wow, I wish that was. We get the 485 approved, we don't need EAD advanced parole at all. Unfortunately, Jay, no, that is not even in the proposal at this point of time. I don't think so that will ever be. The reason is that they have to do a lot of inquiry checkups before they approve the 485 application though. Yeah, we should still argue them, they should approve the 485 application within 6 months though, but premium processing will not be a proposal that I would be, because there are a lot of technical things that they need to do they cannot adjudicate in the premium processing.
Jagar wants to know if we have any I-485 Supplement J receipts received. This is for those that we submitted after the January announcement with the new procedure and filing of this California address. Just a handful. We've been filing quite a few of those, especially that first week. Everyone jumped on it and wanted to get it filed immediately, so we did that. But less than 10 receipts, probably maybe five or six receipts
out of 80, 90 that I filed from my office.
Yeah, so not good processing there.
Momo Lee has this question, can H1 be straight reinstated after using the Gc Ead? Yeah, you can. I mean, if you have the H1b approval with I-94, just go to Mexico, you come back. As long as you're working with the same company in H1b and your job is still there, you can come back on the H1b saying that I have H1b with Coca-Cola, I'm working with Coca-Cola, I'm going to be working with Coca-Cola, then you don't have any problem. You can move from EAD to H1b.
Mishra says, I've interfiled my medicals to downgrade to EB-3. Can I use the same provider to reissue me another medical with the same lab test date and then send that with a refiling? I don't see any reason why not, especially because now they've extended the validity of the medical exam, so the signature date of the doctor does not have to be within 60 days of filing anymore.
Margarita switch, is it good for the H4 extension in EAD are pending? Yes, the Margarita is very good. If your H4 I-94 is still valid and you have already filed the H4 plus EAD, you can go to Mexico. We get a lot of good reports, except that one guy had some technical issues in BWI airport. I think so that's in Dulles, in Washington DC area. But otherwise though, we're having good reports from the people who are doing the Margarita switch with regards to H4 EAD, H4 extension. And after coming into United States, you don't have to do anything. I mean, your EAD will be adjudicated in the right time. You don't have to do anything.
Humus says, I used the AOS EAD for 2 months and then got the H4 and H4 EAD with the I-94 card. Can I just start using the H4 EAD? The employer kept a copy of the work authorization. I don't need to submit an I-9 every time. Well, because you started using the AOS EAD, you're no longer married to your H4 status. You're now in adjustment of status. So because you received the H4 approval, that does not put you back in H4 status. I think the only way to do that is to travel, come back, maybe through the Margarita switch to get back on your H4, make sure that you have a valid advanced parole when you're doing that so you don't abandon your adjustment of status. But I think only travel gets you back to the H4 to allow you to use the H4 EAD if you wanted to.
Sejal Patel, I have received an EAD card yesterday, and the bottom of the service says advanced parole also. And while the online status that advanced parole is not approved, Well, that's fine as long as your bottom of the card says advanced. It's also is advanced parole. Just the online status is not reflected. You can still use it. I don't see that as a problem.
Simbu says, my H1b receipt notice starts with IOE. Where do I file the H4 EAD? Yeah, those receipts are now coming with IOE instead of the SRC or LIN or WAC, but you have to look at the bottom of the receipt notice. That will give you the actual service center where the application is actually pending. That's the address that you use to determine where to file your H4 EAD.
A lot of people are asking with regards to the premium processing. Let me make it clear though. There is no premium processing for H4 EAD. There is no premium processing for the adjustment of status EAD. There is no processing for the adjustment of status. There will be a premium processing for EB-1C. There will be a premium processing for the EB-2 national interest waiver. These are the only two things that have been added right now. For the rest of the people, no premium processing. Sorry guys.
Fatima says, I got my I-94 extended at the Mexico border and I'm working on the 180-day extension, filed my H4 EAD standalone. What if my old H4 and H4 EAD get denied? Can I still work? Well, the auto 180-day extension is only applicable when you have the extended I-94 and a pending EAD. So if your EAD application gets denied, I believe that cuts off the automatic extension and you would have to stop working.
Soham has this question, does day one CPT change of status denied, does a margarita switch work for it? Unfortunately, no. The reason is that your H1 doesn't have an I-94. This margarita we are speaking about, you must have a 797 with the I-94. That's the most important thing you need to have. If that's not there, so in this case, definitely it doesn't. You have to still go outside the country, get the stamping, and come back. Going to Mexico, no, you may not be allowed to come back into this country.
Tango Man from Facebook says, my L1A and EB-1C is filed in concurrent. Am I eligible for premium processing? And what about my family also? So the EB-1C will be eligible for premium processing after the next 60 days. We don't know exactly when, but sometime in the near future. But it does not premium process the concurrently filed I-485, which is the adjustment of status. And that's what your family members filed. So they also won't get any benefit from it. So the only thing it does is speed up the processing of the I-140, does not change the processing time for all of your 485s.
Is there a way to litigate USCIS and waiting green card applications? Unfortunately, we tried. The courts are reluctant based on the law, how it is being done in the Congress though. The courts don't have jurisdiction, so they're not entertaining litigation on the delay of the 485 applications though. However, you can argue with regards to if your EAD or advanced parole is pending though. For a long period of time, litigation has a good chance of working.
Janet says, are any interfiling cases to EB-2 who previously downgraded to EB-3 being approved? Not in our office. We have not gotten any interfiles, any action on any of the interfiles that we did, even before the interfiling guidance came out. Some people were choosing to interfile before that. No action anywhere.
A lot of people are asking questions with regards to the EB-1C interfiling. EB-1C interfiling, EB-1C premium processing, not interfiling. Within 60 days, we will get the instructions when we will be able to file the premium processing. Can we do the premium processing today? No. Can we do it tomorrow? No. Within 60 days, the USCIS will direct us from this day onwards, they are going to accept the premium processing. No matter where your I-140 is pending, at that point of time, we can upgrade it. Now, even though your application is already pending though, you can still upgrade your application to premium processing. The cases that are that you file for new, you can do it. The cases that are pending, you can upgrade them to premium processing.
Aria says, my last name is misspelled on my 485 receipt notice. I raised a service request 7 months ago, and they said they would correct it during adjudication. But now my case was transferred to the NBC, and my last name is still wrong on the transfer notice. Should I create another service request? Yes, absolutely. I don't trust USCIS just because they say they're going to do it. They don't necessarily do it. Obviously, they haven't done it yet. Since your transfer notice came with the misspelling, go ahead and do it again.
People are proposing that we should only answer the questions to the people who have written letters to the congressman or the US director. We're going to implement that from next week onwards. If you have not written letters to the congressman or the senators or the USCIS administration, the drafts of which have been provided there, we are not going to answer the questions. We're going to only try to answer the people who said we wrote the letters to the congressman or the senators. From next week, we're going to try to implement. That's a good proposal that you did it. We'll try to implement because we want you to be taking the action too. I mean, not just we tell and you don't do anything. That doesn't serve the purpose, because we want the USCIS to cut down the time. We want the wastage of the green cards to be very minimal, if not zero.
MK has an H1B stamped until October 2024 and wants to know if he needs to go for stamping again if he changes his employer on H1B and visits India. And will there be a problem at the port of entry coming back? So the visa remains valid even though it has your old employer's name and your old employer's approval notice, I-797 petition number on it. You can use it with respect to a new employer. Just make sure that you show your new approval notice along with that visa at the port of entry so that you get the correct end date on your new I-94. Sometimes officers will give you the end date of the visa rather than the end date of the new I-797 approval notice. So check that before you walk away.
Good question comes from Kumar Kesavan though. EB-2 priority date is current. Will interfiling locks the kid's age? Now, you didn't tell whether it is final action date or is it final action date or is it filing date though. So there are a couple of things that need to be there when you are interfiling though. I want to note them down. Your child must still be under 21. The final action date has to be current. Of course, your I-140 of EB-2 must be approved. Your 485 is already filed, so you're covered with the fourth done though. So all these four things have to be there though. If only the filing dates are current, it will not lock the age though. And especially it may be dangerous. If your son is already locked in EB-3, now you're going to file with the filing dates, you may endanger your child's green card application though. So you have to be careful. The final action date, if the final action date is current and if the child is still under 21, you can interfile. That's a good time for you to interfile. So I'm telling you one thing. The final action date is current, the child is under 21, and I-140 is already approved. It is probably worth filing for the interfiling for you.
Ram Gopal wants to know, can an H-4 kid use the Gc Ead to get admitted into college? And if yes, will that kid be considered as an international student or a local student? So yes, they can use the Gc Ead for getting into college here. They don't have to rely on getting an F1 or they don't have to rely on their H-4 status. And just because they're using that Gc Ead to get into college does not mean they're in adjustment of status and married to that green card, because they're not using it for work purposes. It's very possible, depending on the school, that they may be considered a local student, not an international student, since they're not applying for F1, but that's going to be based on the school's policy.
Yeah, I myself, Emily, was in that situation before. I was not a kid, but I was a spouse, and I used the EAD to go to the school, and I said that, look, I've been living in this state for 12 months, provided all the bank evidence though. They did consider me as a local and did not, so they waived the out-of-state tuition fees for me. Yeah, so you need to collect the information that the child has been living in state or the parents have been living in state and collect the evidence. They should be giving you in state and stuff out of state on the EAD. That's what happened with me.
All right, KL says, do I need to be on an H1B to file a new 485 in EB-2? My earlier 485 was filed through EB-3 and I have that EAD and advanced parole. Yes, you do need to be in a non-immigrant status in order to file a second 485. You can't rely on the EAD or advanced parole and be in adjustment of status. That does not allow you to file a second 485.
Does physical therapist qualify for NIW? Well, just because they're a physical therapist though, that it does not automatically qualify for it if they have the skills that are needed. If they are really in the national interest, they definitely may fall into the national interest though.
They do already get Schedule A, so both of those categories do not have the labor certification requirement, but they do. The Schedule A does have to be sponsored by an employer.
Yeah, that's the only difference though. So there's not technically much advantage by doing a national interest waiver because the physical therapists don't have the labor certification requirements.
Pradeep says, is it okay if my spouse leaves the country on an H-4 after filing the 485, or do we have to wait until we get the receipt? Well, it is smart to wait for the receipt because the main thing to know is that in order to file the 485, you have to be in the U.S. And what if, knock on wood, it doesn't happen, what if her 485 is for some reason rejected and she's left? You can't turn around and refile it because she's now outside the country, and they won't honor that original filing date if it was filed incorrectly and that's what caused the rejection. So there is some risk there, but if you're very confident that the application is properly filed and will be receipted eventually, technically yes, you can travel either on H-4 or wait for the advanced parole, but there's a little risk there.
Answering the question for the person who have written letters to the congressman or senator. Interview completed on March 16, 2022. Officer said it will take 3 to 4 weeks. Can a person get the green card if the dates retrogress though? No. Unfortunately, no. The green card has to be issued when the dates are current. So if later on dates retrogress, you will not going to get the green card. Your 485 will be pending. A lot of questions on that. People are speaking about this HR 4521. We don't see a chance that it's going to be passed through the Senate. So we are not paying attention to it, Shiva. A lot of questions are coming on it. We're not even looking into it because it's not serious for us.
Jagannath, spouse traveled to India on an emergency. She has the approved advanced parole, but then last week her green card got approved. Does that invalidate the AP? How can she enter the U.S.? So technically, yeah, you don't have an AP anymore because you got the green card. However, we have had people that were able to use the AP to get on the plane, land in the U.S., and then CBP is able to confirm that you are in fact a green card holder. So she should still be able to travel back to the U.S. in that situation.
Emily has already updated on the interfiling things, guys. We have filed, from my desk, we normally update because there are a lot of other lawyers in our office though. I personally myself have filed about 70, 80 interfiling somewhere between January and February of 2022. As of now, we may have received only 6 or 7 485J receipt notices. Not a single case that we have interfiled have ever got approved as of today though. We have also started interfiling way before January of 2022 when the EB-2 dates start moving though. As of now, we haven't got a single approval for the interfile. I don't know what to do because we're trying to do everything what they are telling us to do, but they're not approving it. So we just suggest you keep writing letters to the congressman.
Ramesh wants to know, can we use the previous employer's I-140 pending time to reduce the child's age when we use the new employer I-140 to file the 485? Very good question, and USCIS clearly said no. You can only use the number of days that the I-140 that is supporting this 485 was pending, not a prior one.
For USCIS or any government jobs, H4 EAD and GC Ead people are eligible. There are some positions where it requires that the person has to be a green card holder or a US citizen. There are some jobs that does not require. For example, most of the teacher positions and some other government positions, most of the positions does not require. But there are some positions which requires that you must be a US citizen or green card holder.
Simbu says, my H1B is approved till 2025 and I'm going to India, but my visa stamp is only valid until July 2022. What happens if I can't get the interview? How will my I-94 impact when the visa stamp expiration doesn't match the I-797 expiration. Well, you'll need to make sure, if you aren't able to get the new visa, that you come back before July 2022 when your visa stamp expires, but also at the port of entry, show both your visa stamp and your extended I-797 approval notice. CBP should issue you an I-94 for the full period of time. If for some reason they don't, you either need to travel again before this new I-94 expires or file the extension again with your employer.
In the H1b stamping, if you cannot get the end client letter, what are the alternative things? You can get a vendor letter, you can get the emails, show them the emails that you have been, and emails that you have communicated with the client, the invoices that the company has done and the payments that they have done, the timesheets that you have submitted to the end client. You can take all those things as an evidence that you have a job at that particular end client, though. This question is for Mary, though. Right now, almost everybody, I mean, very rarely anybody is not eligible. Everybody is eligible for Dropbox. So definitely, this is the right time for you to go for stamping. Questions are coming with regards to whether there will be a spillover in October of 2022. That means for the fiscal year of 2023. We do expect some spillover. It may not be the same amount that we got for this year starting in October 1st of 2021, but we are expecting, my guess is anywhere between 40,000 to 70,000, that's my guess, will be the excess green cards that will be available. But my main concern is, why waste 100,000 green cards right now? So I will try to fight for them first, though.
Perry says, once I move to the EB-3 Gc Ead, is there any possibility to upgrade to EB-2 after changing employers using that EAD? Not easily, because in order to upgrade to the EB-2 I-140 approval with your old company, that old company has to be supporting that and be willing to sign the Supplement J, which they're probably not going to do after you've left them. Otherwise, the only other way to do it is for the new company to file a new labor certification, new I-140, and then interfile that.
The Praveen Khorasan has this question that is the DOL processing time is there a consistency in processing on the basis on the day we submitted, though? Well, compared to the immigration, DOL is processing the cases. When we noticed it, somewhere in the month of September of 2021, Praveen, is what they are. So the dates are a little bit confusing, though. Sometimes it may be the guy who filed in September 25th may get the approval, but the September 2nd week might be still being pending. But we don't notice July cases to be pending, though. We don't see November cases getting approved. Like the way we see in the USCIS, the ones we filed in 2020 October are still pending. The ones we filed in 2021 October gets approved, though. That definitely doesn't seem to be way DOL, Department of Labor. But yeah, there may be a variation of 10 to 15 days, at the most 1 month, but I have not seen more variation than 1 month in the DOL. So overall, I have to give a credit that there is a first come, first serve basis in the DOL, but when it comes to the immigration, there is no first come, first serve, and there is a black hole in the Tax Service Center. I don't know what they are doing. They are segregating the family. One person gets transferred to the National Benefit Center. The rest of the family members remain the same. One person gets the green card. The other person doesn't get the green card. It is really a mess in Texas Service Center, though, and also to some extent to Nebraska Service Center. When it comes to the DOL, it definitely is in a good position.
Finindra says, I got my EAD card, and can I travel to India, come back with advanced parole? H1b is expiring in June 2022. Can I still extend my H1b if I use the EAD? So first, make sure that your EAD does have the notation at the bottom of it that says it also serves as advanced parole. Because you can't travel on an EAD, you can only travel on an H1b visa stamp or advanced parole. So let's assume that you're going to go and come back on your advanced parole. You have to come back before June 3rd and then file the H1b extension. So yes, when you come back on advanced parole, you're technically using that EAD to come back in, but you can still extend the H1b after that as long as you file it by June 3rd because you're back in the US before June 3rd.
She was telling that the HR 4525 one has been approved in Senate. We will update you. I will update you on Sunday TV show that I have with TV Asia about the HR 4521. With regards to Hemant, though, the CBP is making cancelled without prejudice. While leaving the USCIS, at the Dropbox appointment, they're asking for in-person interview and not accepting the Dropbox waiver. Ah, that's very rare. Why would the CBP do the cancel without prejudice, though? That's definitely Hemant. That need to be alerted if that happened with you. We have not noticed it. I'm not telling it didn't happen. It has happened with you. I definitely recommend that you contact a lawyer, though, because CBP making the cancellation at the airport, I mean, that doesn't look like right, though. And you're telling it's at the Dropbox, so I'm a bit confused because CBP is not there at the Dropbox. CBP is only there when you're exiting the country, when you're coming into the country. So definitely either there's a mismatch in what you're telling, or if they did when you left the country at the airport, that is definitely a serious matter to be looked into, why they cancel without prejudice. I got E8 and AP and EB-3 485. I have refiled now. Can I do a renewal based on the EB-2 485? You can just file a 485. You can file the E8 in advance for an EB-2. Absolutely, you can.
Kanea says, can I refile the 485 if my daughter has used her EAD? You can, assuming you've maintained your non-immigrant status, but your daughter will not be able to file a second 485 after she's used her EAD, which basically means you should not file a second one because you need to be approved based on the first one so your daughter can get it. So you need to look into options for your daughter to get back into non-immigrant status if she hasn't switched to F1. She's still eligible for H4 because she's under 21. Let's see how you can get her back into H4 status, maybe through travel, so that she can file with you.
EB-3 priority date is 2013. May prediction in December 2022. A lot of people are also asking question, are there any green cards available in EB-3? We haven't been notified that the green cards are not available in EB-3. Previously, they used to give indication how many 485s are pending on EB-2 and EB-3. With the new reports that we're getting, they're not giving that report. They used to give a report which country nationals 485 is pending and which particular category. We don't see that in the new reports, though. We did file a freedom of information, so we don't have an idea. There is a chance that they have used up a lot of EB-3 applications. There's a chance for it, but we have no clear idea at this point of time.
Balaji says, I have an approved AOS EAD card. Can we travel outside the U.S. With this? I'm not sure if you're asking with this card. So make sure that it says also serves as the I-512 advanced parole at the bottom of it. An EAD card by itself is not a travel document. So if it doesn't have that notation, then you need to have a non-immigrant visa in order to travel and come back.
Hemant is reporting that the cancellation without prejudice is an expired visa. If it is an already expired visa, though, you're fine. I don't see any problem in it. You're good. I don't see any problem with that, though. If it's already valid visa, they're doing cancel without prejudice, then definitely that's a problem.
A couple of questions about when the NIW premium processing will be implemented. We don't know exactly. We know it'll be at least 60 more days from tomorrow, but it could be longer than that because we have to wait for USCIS to also update its website of when they'll start accepting those. Sure, they have to update form instructions, update the 907 form in their website, so they'll take their sweet time, but it should be before September 30th.
Abhijit Sen is asking, is it worth filing a lawsuit for the delay of the Gc Ead? Definitely it's worth filing for Gc Ead. Not for the GC itself, but for the Gc Ead. Karthik has a question that he has a traffic ticket which has been cleared. Does he need to mention on the 485 application? The answer is no. If it's traffic ticket where it's less than $500, that you have paid a penalty, traffic ticket, okay, only like a speeding light, a red light or speeding ticket, definitely you don't have to mention it. Now, if it's a DUI or anything where you paid excess $500, it's always worth speaking. DUI, definitely you have to mention it. If it's more than $500, I would recommend to contact the lawyer to see if you have to mention. There are some problems, especially if you are mentioning the speeding tickets. DUI, you have to mention, okay? If it's a speeding ticket. I went to an interview and I asked the officer, why did you interview my client? I mean, that's only, why are you interviewing my client? The officer just said, because you answered, I did not, but I went for the interview. This guy answered yes for the arrest, for the, have you committed any crime? He mentioned yes. We don't know if this is the only crime, traffic ticket, or is there any other crimes that have been committed though. So sometimes answering yes to the traffic ticket as a crime is actually causing more delays for the 485 application. So if it's a traffic ticket less than $500, not the DUI, do not answer, do not mention it in the 485 application. It's going to complicate it, guys.
Arun asks, can I change the job within 180 days after an interfile? I have the I-140 approved in both EB-2 and EB-3. Interfile was done in February. Does AC-21 portability reset with the interfile? 485 has been pending since October 2020. Well, if you ask USCIS, they say yes, the clock resets when you do the interfile. So you have to wait 180 days from the interfile in order to be eligible for AC-21. Now, I think there's not any legal authority for this, and there's a good argument that it should not apply. And then the question becomes, okay, so what are they going to do if you do port early? It at least should not impact your EB-3 ability to get approved, because that one did clearly qualify for AC-21. So it is a gray area, not in the eyes of USCIS, but I think that's something that can be attacked. Hopefully we will get them to change their opinion on that.
Question on repeated questions on the premium processing of EB-2 NIWs. Most probably within 60 days, though, we will come to know if within 60 days of from now onwards, we will come to know on which day EB-2 national interest waiver we can file the premium processing.
Sutra says, how can we check the processing time for the NBC in the USCIS website? Nebraska, Texas, those are all listed, but only the field offices. So yeah, NBC does not list its own processing time. The only way to look it up is to actually look at your field office processing time, and that is reflected with the NBC processing time, but they don't separately list their own processing time.
What are the supporting documents we should carry along with the advance parole when we travel outside the country? You just need to carry the 485 receipt notice, and that's all you need. Of course, I don't have to tell you, but you have to carry the passport. But one thing, Kumar, is that when you travel into United States, so some of the airports don't have the processing capacity at the same place when all the people are getting into the country. They may getting into the CBP line, though they may take you to the secondary hearing, and you may have to wait for 15-20 minutes and speak with a different officer before they let you go enter into the country. This happens with advanced parole, but we have no problem. Nobody have ever been denied just because you have an advanced parole and you're coming to the United States. We have never seen any denial. Parshuram has this question. With employer A, H1b rejected in 2016, afterwards green card processed by the same employer, same company, will it be a problem for getting the green card? No, we don't see that as a problem. You're fine. In 2016 to 2018, we have seen a lot of denials. Thanks to the Trump, we've seen a lot of denials at the time, and then they went back to India, got back, and some of the people, the H1b rejected when the I-94 is still valid. We refiled it, got it, but it will not cause any. You should not cause any problem in you getting the green card.
Dan and Jay, similar question. My F1 visa was denied in 2002. Now that I'm filing the 485, I've mentioned it. Is that right? Yes, the way that the 485 form is worded, it asks, have you ever been denied a visa? It doesn't say within the past 5 years or at a certain time frame, doesn't specify what type of visa. So the fact that you had an F1 denied, even though it was 20 years ago, yes, it should have been disclosed on the 485, so that is correct.
After good question from Arun, and he has written a letter to the senators and congressmen. Thank you for doing it. How many weeks and months does the transferred case to the NBC get approved? Good question though. One thing we have noticed, a lot of cases are getting transferred from Texas and Nebraska Service Center to the National Benefit Center right now, which is a good thing for us. We cannot tell how long it's going to take for the NBC. There are some cases that may be approved in 3 to 4 months if the prior date is current. There are cases that may be pending for more than 1 year also. So overall though, the amount of cases that are getting approved in NBC in a shorter duration will be way higher than Texas and Nebraska Service Center. So it's a good news that it has gone to the National Benefit Center, but can there be a miracle that as soon as it went to National Benefit Center, your case can be approved immediately? There is a chance it could be. There is a chance it could delay though. But there are better chances your case will get adjudicated faster because the amount of applications that they are approving every quarter is way better than Texas and Nebraska.
Shal 895 says, can I file the H-4 EAD for my spouse based on the approved I-140 from my previous employer? My new employer is yet to file the labor. So assuming that your I-140 has been approved for at least 180 days and the employer did not withdraw it during that 180-day period, yes, absolutely. You can keep using the old I-140 approval for continued H-4 EADs and continued H1b extensions beyond the 6-year limit, and you can keep that priority date.
Papani, Margarita switch. My attorney says that once you use the EAD and AP, you cannot come back on H1 and H4. Not true. We have done it for many people, no problem. And we filed EB-2 again for them for a 485 application, no problem at all.
All right, I think we're about out of time for today. Thank you all for joining us. Please remember, if you haven't done it already, send those letters, use our templates, contact your congressman, your senator, the USCIS Office of Public Engagement, the Ombudsman, and Zoe Lofgren's office. We've got to get our voices heard. We're not waiting until the summer, the last minute, this time around. We need them to get their act together now so that we don't waste those green cards.
Thank you for tuning in.